All right, we might just get started. There may be people that are joining us late, and that's fine. This is being recorded, and so you'll be able to listen to it later. Now, before we get started with the actual substance of the presentation, I'd just like to do a quick acknowledgement to country. Appreciate that we're probably going to have a lot of guests from different parts of Australia, different states and territories. So we'll do a general acknowledgement of country in the spirit of reconciliation. Avant acknowledges the traditional custodians of country throughout Australia and their connections to land, sea, and community. As a national organization, we pay our respects to elders past and present of the lands on which we gather and work, and extend that respect to all Aboriginals and Torres Strait Islander peoples. All right, so I'm going to be working the slides for the moment. Apologies, there's sometimes a bit of a lag in getting them through. So the focus of this webinar is basically to give you an update on the new reforms to the Privacy Act, and also to have a quick chat about cybersecurity, because that's going to be really relevant in terms of how these reforms have been discussed and now implemented. So essentially, we're just going to navigate the complexities and give you some tips to help prepare you and be mindful of the areas of risk that come with now these new changes, but also how you as organizations, as individuals in the health industry and the health profession can protect yourselves and prepare. And rather than survive, we're looking at thriving. So this is a general disclaimer. Please be aware that this isn't any legal advice or professional advice. This is really just an education piece. It's a summary and general overview of matters of interest. So before we get on to the agenda and to talk about everything, I might just do a quick introduction for myself, and then I'll let Chris do one as well. So my name's Marko Novikov. I'm a senior associate at Avant Law. Avant Law is one of the divisions of Avant Mutual. I work with clients that include health service providers from individual doctors to medical practice owners. And one of the areas that I assist and advise our clients with is in relation to privacy. And that's part of the reason for this presentation as well. It's an area that we cover a lot, and we also want to make sure that our clients and generally those in the health service profession industry are aware of what's happening and how to prepare for it. Chris, I might pass it on to you for a quick introduction.
Thanks, Marko. Afternoon, everyone. Thank you very much for allowing me to come and speak to you today. My name is Chris Watson. I'm the CEO of Collab. We're a cybersecurity consulting firm, and in short, we help organisations manage the life cycle of their data from an information security and cybersecurity perspective, making sure that you have the right frameworks, making sure that you do the right testing, and making sure that you have the right plans in place should anything go wrong. Started off my career in law enforcement back in the UK over 30 years ago now, and have worked right through the sort of the life cycle of cyber forensics, computer forensics, cybersecurity, and incident response. So thanks very much for joining us today, and I think you'll find this informative.
Thanks very much, Chris. And again, we're very glad to have you on board. So as a basic agenda, we're going to look at what the current privacy laws are, what are the updates to the Privacy Act, and most importantly, what are the legal and commercial implications for health service providers? And then Chris is going to move on to talk about cybersecurity. And part of that discussion will also include talking about notifiable data breaches, because that's relevant, particularly if you do have any data breach that may qualify as one that needs that notification to those that have been impacted, in addition to the OAIC. And at the very end, we'll have a general Q&A session. All right, so let's get started. So privacy and privacy laws. Obviously, you would have heard a lot of information thrown around about what is privacy, but if you think about it from your perspective, dealing with patients, treat it as an extension of what is patient confidentiality. So if I had to put it in 25 words or less, which we've done in this slide, if you handle information that can identify someone, make sure you collect, store, use, and share that information safely and properly. So there's a number of privacy laws that apply in Australia. I'm going to focus on the Privacy Act, which is the Commonwealth legislation, and the Australian Privacy Principles, which underpins the framework of the Privacy Act. Many of you already know this information, so forgive me, I'm just going to go through it very quickly for some of those who may not be as familiar with it. So personal information is any information or opinions about an identified individual or someone that can be reasonably identifiable, and it includes sensitive information. This is where it's relevant for health practitioners and health service providers. Sensitive information includes health information, but also race, religious, or ethnic origin. The key to the Privacy Act is that it doesn't apply to all organizations. There's a bit of a threshold. And the general threshold is this. If you've got, as an organization, an annual turnover that's 3 million or less, then the Privacy Act does not automatically apply to your organization. However, you can voluntarily apply to, or what's referred to as opt-in, so that the act applies to you for governance reasons and for community trust reasons. There's good reasons why that would be something you may want to consider if you're not a health service provider. But if you collect or store health information of any kind, then the Privacy Act says that it automatically applies to you. And the reasons are quite understandable and justifiable. Health information is so sensitive, it's very personal to people. And so they'll obviously be quite concerned if there's any misuse of that information. And as I mentioned, there are other state and territory privacy laws that apply as well. So for myself, I'm based in Victoria. We have a state privacy act that's related to government entities, but also another one referred to as the health privacy principles that apply under the Health Records Act. And so that's directly relevant for health service providers here in Victoria. And in your different states and territories, you'll have something similar as well. So compliance with the privacy law is really important for a number of reasons. There's the obvious legal ones. If you don't, there's potential penalties that come with non-compliance, and that's something I'll get to a little bit later in the presentation. But particularly if you are medical practice owners and you own the practice under a company structure, then you will have duties as a director to the company. And as I'll discuss a little bit later, those duties do include issues that are emerging areas of risk for organizations. And that includes, as I'll get to very quickly, directors having to ensure they're transparent and accurate about AI-related disclosures. And that includes the company's integration of AI. And we're also seeing that directors are increasingly expected to prioritize cyber resilience and comply with data protection regulations to avoid potential liability. So there's actually a case a number of years ago that really drew this to the forefront, and I'll talk about it shortly, but it has direct implications if you are medical practice owners under this company structure. Essentially, as a director of a company, you have certain minimum duties that come with being a director. And if I could put it in a nutshell, you just need to discharge your duties with reasonable care and diligence. And that is covered under what's referred to as the Corporations Act. I won't get into the details of that, but just bear in mind that as an owner of the company, as a director of the company, you're going to have certain obligations because the actions of that, your actions directly impact on the company through your management decisions, but also through the privacy policies and the different procedures and practice documentation that you have. So when it comes to other reasons, obviously we got to think about it from a practical and commercial perspective as well. Chris is going to talk about this shortly, but the health industry is actually the highest targeted industry from ransomware. And we've got a lot of data that's released by the Office of Information Commissioner in this respect. And so it's something to be quite mindful of. Your patient records are your business assets, so you've got to protect them. And obviously, if you're dealing with patients, if you're dealing with the wider community, you want to make sure that there's that level of trust that you have with your patients and the wider community when it comes to protecting their personal information and their health information. So I mentioned earlier, there's the Australian privacy principles, referred to them as APPs, that essentially underpin the Privacy Act. I can't go through all 13 of them. It'll just take up too much time. But what I'm going to do is just talk about some of them very briefly that are important for the context of this presentation. Most important ones that we'll get to talk about and as they relate to the reforms, are the open and transparent management of personal information, the collection of personal information and how it's used, how you deal with it, how you notify others of the way you collect their personal information, the use and disclosure of it with or with consent, and in terms of if there's any cross-border disclosure, that's something you got to be mindful of. You still got to ensure compliance with it, so you've got really take due care in dealing with third parties that may be overseas. There's the adoption and use and disclosure of government-related identifiers. That's going to be relevant for the health industry. And of course, you have to give your patients the opportunity to know what personal information you hold about them, but also to correct it or update it as necessary. So this is just a very brief timeline of how we got to the stage where we're at, where there was the changes to the Privacy Act that were approved or received royal assent on 10th of December. So really the discussion started quite some time ago, but really came into wider consideration within the government as of February 2023. The Attorney General's Department had released a report on a review of the Privacy Act. Obviously, that was influenced by reasons related to increased risks of cybersecurity and how mobile data is now, and how easily it can be transferred and shared, including across overseas jurisdictions. The Australian government prepared a response to that report some months later in September. In November last year, the Privacy and Other Legislation Amendment Bill was passed by Parliament, and then it came into effect in December last year. So I'm going to go through a number of changes to the Privacy Act that apply now, but also there are certain reforms that don't apply until later this year and others that actually won't really take effect until December 2026. So it gives you that grace period to prepare. And I think that's going to be really helpful when you consider the implications of these changes and the ability of organizations that are APP entities that are captured by the Privacy Act to be able to respond with resilience and given the appropriate time frame to do so. So the first APP that talks about, information that you collect about your patients for the health service providers and your transparency about what you do with that information. So that includes, for example, having a privacy policy. So APP1's now been amended to require organizations that use automated decision-making to disclose this in their privacy policy. There's a bit of a grace period that it's going to come into effect as of December 2026. But this is something you need to be mindful of now because we're seeing essentially a revolution in the way that healthcare is delivered, and that's coming through AI programs, AI services. And so what we're going to discuss later in the presentation is instances where you may have that sort of technology or software where it's going to be an ADM, and you have to make sure that this is disclosed in your privacy policy. So APP 11 deals with security measures. And essentially what the reforms say now is that you need to take reasonable steps to protect the security of the personal information. So that's not just technical, but also organizational measures. And the reason I'm bringing that up, and the reason that it's part of the reforms is, unfortunately, there's been a misunderstanding by a lot of ATT entities that when it comes to protection of personal information, that it relates almost entirely to technical measures that you take with your IT. But it's more than that. If you're a medical practice, you're operating as an organization. You collect personal information, not only of patients, but also of staff. Your staff need to follow policies and procedures. So just having a certain kind of technology isn't good enough. What's expected of you now is to be very proactive. So it'll entail things such as training your employees and your contractors on understanding the privacy policy and complying with it, because it's all about taking relevant steps to ensure that you've got the appropriate governance for that data protection. And unfortunately, as we're going to discuss, if there is a breach of the requirements under the Privacy Act in terms of protection of that personal information, there is the possibility that the organization can be hit with a civil penalty. And what's happened is the Office of Australian Information Commissioner has now been granted wider powers, and that includes for issuing infringement notices and compliance notices. And I'll get to that shortly. One very controversial issue that's arisen is the new cause of action in tort for a serious invasion of privacy. That doesn't take effect until later this year, but it's one that's received a lot of attention from organizations and associations within the health industry, including the AMA. They released their own position paper on that and some submissions. And for justifiable reasons, they had grave concerns about the impacts of these new changes on how health service providers deal with their patients and collect personal information, not only of their patients, but of family members in case there's any issues that need to be discussed about genetics and diseases and the provision of healthcare. So fortunately, the government's come out with a discussion on that, and I'll get to that shortly, just to avail some of those concerns that were raised earlier. I'm not going to spend any time on this as part of the presentation, but I just wanted to let everyone know when it comes to overseas data flows, there's a new change in the Act that refers to whitelisting of prescribed overseas countries. So some countries like Australia have really good privacy laws. Others may not. And so if you do share any information about your employees or your patients overseas with third party providers, you still have an obligation to make sure that information is protected. And so you need to ensure that whatever policies and procedures they have for the protection of that information comply with the Privacy Act. But what's happened now with this change is if the government decides to whitelist a country, saying this country has the right kind of privacy laws, then you don't need to comply with APP 8 when it concerns overseas data flows, because the government's already decided that that country has that sufficient privacy and protection of personal information. There's only one important caveat, and that's under Section 77 of the My Health Records Act 2012. There's still a general prohibition against outsourcing of national digital health record data to contracted overseas third parties. If this is something you're concerned about, I do recommend you get professional advice as soon as possible. Apologies, just a little bit of a lag. There we are. So I gave you a brief summary of those changes, and now I'm just going to go through them in a little bit more detail because they're particularly relevant for health service providers as it relates to what we call administrative burdens for what might be simple administrative breaches that are completely avoidable. So the Office of Australian Information Commissioner, it's responsible for enforcement investigation of the Australian privacy principles and notifiable data breaches, something Chris will speak to you about. The OAIC has this new power to issue infringement notices for breaches of specific APP. So it doesn't apply to all of them, but certain ones that they've deemed to be the most important when it comes to having these wider powers of enforcement. So one typical example is a non-compliant privacy policy. This is one of the easiest things for you to manage as part of your organization. If you get the appropriate professional advice, then you'll understand what your obligations are in accordance with the APPs. But not having a compliant privacy policy can get you in trouble with the OAIC, and you just don't want to deal with the burden of having to pay a penalty for something that really, with the correct and the appropriate professional advice, can be resolved quite easily. Also, if you have a non-compliant notifiable data breach statement. Alternatively, the OAIC may also give an entity what's referred to as a compliance notice if it reasonably believes that the entities can contravened any of the provisions for which one of those infringement notices can be issued. This is really tricky from a legal perspective, and this is one of those that lawyers are going to love to dig into in the future, but we don't have time for that. But I just wanted you to be aware that the powers have expanded to this degree where if the OAC just comes into a mindset that perhaps there's an issue related to your compliance with the APPs, they have this right to take action now. How that can arise is anyone's guess. But if you think about a situation perhaps where a patient deems that there's been a privacy breach and then they alert the OAIC, then there's right away that can kick off the investigation process. and the opportunity there for infringement and compliance notices to be issued. The way we see the impact on this for health service providers is that really it's another administrative burden for you, and it's for an administrative breach. So again, just by not having a compliant privacy policy can get you in trouble with the OIIC. And so for that reason, it's really important, again, that you get that privacy policy appropriately reviewed. So this is also going to be a controversial one. There's a lot of questions that arise now with respect to the use of AI in healthcare. And I want to point out that if you look on the bottom of this PowerPoint slide, you see that I've referenced two web page articles from Avant that has great information about introduction to artificial intelligence in the healthcare and also how AI can actually make your job easier. Because we know that there's an influx of AI now in terms of the delivery of healthcare services, it's incumbent on the government and organizations to really appreciate what are the potential impacts of using AI, particularly when it comes to privacy breaches. So first, want to let you know how the government's defined what an ADM is, automated decision making. This is when a computer program uses an individual's personal information to make a decision or to do a thing that is substantially and directly related to making that decision. And it could be reasonably expected to significantly affect the rights of the individual, whether adversely or beneficially. The reason I say that is because healthcare can constitute a high-risk application for AI, potentially resulting in patient injury from system errors, increased risk to patient privacy. And so you need to make sure that you're aware of how the system operates and any ways that you can contribute to a breach of personal information by your use and application of that software. So the new changes relate to APPs 1.7, 1.8. Again, this doesn't kick off until December 2026. But what's important for you to know is that these new laws, they will apply as of December 2026, but all the actions you take now can be scrutinized. So what you want to do is look at your current privacy policy, get it reviewed. If you use AI in any which way, you need to be transparent about it in your software, particularly if this automated decision-making applies to how you make a decision about treatment of a patient based on use of AI. And just to give you an idea of the types of AI in the healthcare system, AI can be used to automate administrative tasks. Obviously, all of you will be aware about transcribing patient consults, but also triaging. There's the clinical use of AI in healthcare, so providing information to clinicians to support their decisions, assisting humans to make decisions. I've given an example there of how AI can observe the ECG signals and detect abnormal cardiac rhythms, and also about making decisions. So things like screening services where an AI can be trained to look for issues. Diagnostics and preventative medicine. Again, all of this information is taken from these two sources that are available on the Avant website. So this serious invasion of privacy is one that garnered a lot of attention, as I mentioned earlier, from organizations and associations or stakeholders in the healthcare profession. And what I'll do is I'll quickly go through what it entails. My apologies. I know this is a very busy slide, but because there is so much controversy around this issue, I just want to be as helpful as I can in preparing you for what to expect and also how to address the situation. So what in effect has happened is the government said, now there's a personal right of action for a person to sue another person or organization where they've seriously invaded that individual's privacy. There's two categories of doing that. One is intrusion upon seclusion. So just think about some of the usual stuff you might have heard of where people are, without your consent, videotaping you or recording a conversation that they're not supposed to do that. They get in your personal space in that way, or misusing your personal information. There is a case I'm going to talk to you about that was a really interesting one in New South Wales involving ambulance drivers. It's pretty much a shocker, but you'll get the sense of why a situation that arose back in 2019 can be used as a justification for saying, well, look, we've really got to consider how this misuse of very sensitive health information can be detrimental to not only the people that have been impacted, but also how to prevent that for the future. So in this way, the way the government sees it is the individual has a reasonable expectation of privacy in all circumstances, and we all do that, especially for sensitive health information. Now, for this tort to apply, meaning it's a civil wrong, in order for it to apply, it's got to be intentional or reckless and serious. So without getting into too much detail about it, if there's something that happens like a car accident, if I can use that as an illustration, you can have someone that's in an accident by negligence, but you can also have someone that gets in an accident because they're reckless driving, and that could be because they're drunk. And so what the government is saying is, in order to reach this threshold of it being more than just negligent, meaning it's a serious invasion, it's got to be intentional and reckless to the effect that you knew this could potentially cause someone some sort of stress or grief because you're breaching their privacy, but you did it anyway. So it's a really high bar to meet. And I'll give you a case example under this next section when I talk about vicarious liability. So I'm not sure how many of you have heard this term thrown around, so forgive me for using the legal jargon, but I'll explain it as best as I can in layperson's terms. So organizations or entities that employ or contract with health service providers could potentially be held vicariously liable for serious invasions of patient privacy committed by their staff or independent contractors. So in this case, imagine if there's a workplace injury and the one person has effectively caused the injury of another. The way the law deems it is, if that person that caused the injury didn't get proper training, if there's something that they did wrong because of not following company procedures or not being properly trained about it, then that company is liable for the conduct of its own employees as it relates to how it impacts other employees. And there's numerous cases about that you inevitably would have heard about for things like sexual misconduct in the workplace. And when it comes to independent contractors, this is a really tricky situation because at law, an independent contractor is not an employee of an organization. So an organization can't be held vicariously liable for him unless it's determined that that independent contractor is not really a contractor, but an employee. And so I won't get into the details of that, but I just wanted you to be aware of how serious it is because it applies to definitely employees, but potentially to these independent contractors. And this was really highlighted in a case that happened in 2019. Some of you may have heard of it, particularly if you're from New South Wales. But essentially, there was this individual that was working with the New South Wales Ambulance Service, and they were a contractor. And they got access to the personal and health information of ambulance drivers. And some of those ambulance drivers had which were called workers' compensation claims. And that individual took that information and sold it to personal injury law firms. So quite mischievous of this person. When you think about the conduct that they committed, that was clearly intentional. They knew what they were doing. They wanted to take that information that's sensitive, sell it to a third party, and make some money out of it. So that's what you can anticipate as the kind of behaviors that are deemed to be serious invasions of privacy. So obviously there's going to be a spectrum there. It's a fine line sometimes between what is negligent, what is intentional and reckless. But the point being is I want to give you that as a case illustration of what can happen. And as part of that case, although it got settled, what had actually transpired is the person that was leading the case as a class action was saying that there was a breach of privacy and vicarious liability for the New South Wales Ambulance Service because of the conduct that happened. So we never got a case decision on it from the court because it settled. But it really, to us lawyers, illustrates the seriousness of what can happen when someone is not properly trained to handle personal information or just acts completely recklessly and gives it away for a mischievous reason, essentially being the misuse of personal information for what this new statutory tort for invasion of privacy is meant to deal with. And again, there's layers to this. So it can't, if you're going to meet the threshold, you've got to go through the fact that it's intentional and reckless, but also serious. So what does serious mean? Well, legislation basically says it's got to be a particular kind of information and the consequences for the interference with the privacy of that individual, the sensitivity of that information, and whether they're a child experiencing or someone else experiencing vulnerability. So think about the case with those New South Wales ambulance drivers that have the workers' compensations claims. Obviously, they're in a vulnerable position because of that. Whether the act was done or the practice engaged in repeatedly and continuously with that particular contractor from New South Wales ambulance service, they did it to a number of ambulance drivers, so not one. So again, this is a pattern of conduct. And importantly, when it concerns your organization as an APP entity, whether the contravening entity failed to take steps to implement practices, procedures, and systems to comply with their obligation in relation to privacy in a way that contributed to that privacy breach. So this is where we're going to go back to, from the lawyer's mindset, advising you that you really got to be mindful of how you train your employees and your independent contractors to make sure that if there are policies and procedures in place for protection of patient information, obviously for the protection of employees' information as well, those need to be followed and your staff need to be trained on it, because if they don't follow it properly, there's the potential that you could be held vicariously liable for their misactions. So just something to be really mindful of. Now, the reason this made such a big deal in the health industry is that there was a lot of concern raised about, well, doctors in ordinary practice, when they're speaking with their patients, sometimes they're going to get personal information of other people, like family members, when it concerns treatment options or concerns that may be issues related to inheritance of certain diseases. And thankfully, the government has come out and what's referred to as the addendum to the explanatory memorandum that just says, look, these are the reasons why we did what we did. These are the justifications for it and how it's going to apply. So what this addendum said is the tort's unlikely to affect the proper activities of a healthcare provider. So that's in light of all the elements which must be satisfied, high thresholds and defenses, for example, in connection with intimate health or family information. So going back to that example I mentioned earlier. And the elements of tort should ensure that legitimate practices such as medical care and research do not attract liability. So there was obvious concerns raised by the AMA and other stakeholders in the industry just about how far this new statutory tort can go in terms of being implicated for organizations being responsible for the conduct of their doctors and their staff, and again, individually for staff and doctors as well. And so what we're hoping is, based on this and based on the existing information that we have out there that's informed the basis upon this legislation, that if it ever does go to court, it's going to be treated with the way that the legitimate practices of the healthcare providers are not going to be used against those healthcare providers where it was necessary to do those kinds of activities for purposes of treatment of patients. Again, I don't have too much time to spend on this. It's obviously something that all of you are going to be far more across than I am in the way you deal with your patients, but I just want to raise it for your attention so you're mindful that moving forward, it's always important that you've got patient consent with whatever you're doing with them. But if you're going to need to undertake certain activities in treating a patient, you should be assured that you're doing everything you've been doing in the past and asking about family histories. You're still allowed to do that so long as it's for a legitimate purpose. And obviously the provision of healthcare to your patient certainly is one of those. So civil penalties, these are unfortunately one of those types of issues that arise when you're a business and you've got to be concerned about outlays. You're going to have fees you need to pay, your rent, your bills. And now, unfortunately, there's also the possibility of paying not only the civil penalties, but paying more than what used to be the case. So it's not going to apply in every instance. As I said, there's 13 privacy principles. But when it comes to these infringement notices that the OAIC can issue, and when it comes to the penalty notices, it's not going to apply for all of them. It's going to apply for certain categories. So to give you examples, And I keep referring to this because I really want to hone in on the fact that it's so important you have a compliant privacy policy. So if you don't have a privacy policy or it's not compliant, well, that can attract the civil penalty. If you don't keep accurate written notes of disclosures of sensitive information for something like a secondary purpose, again, that can attract that civil penalty. If you don't comply with the opt-out rules for direct marketing, now some of you may or may not do that, but if you do, as you know, the rules require you to say if you send any messaging that can be considered direct marketing to your patients, they have the ability to opt out and the way to do that. And if someone comes to you, a patient and says, look, I need you to correct my personal information. If you don't do that in a timely manner at all, again, that can attract liability as well. So that's a basic overview. When it comes to the penalties themselves, I have to throw around the figures because I want to make it apparent to you just the seriousness of why it's so important to comply with the privacy laws. So if we go back to the previous issue I was talking about with the serious invasion of privacy, as I said, that's a high threshold to meet, but it's because it's something that's considered so serious. So if it's a person that commits it, potentially they could be fined up to 2.5 million. Does that mean it'll go all the way up? Not necessarily. It really depends on the circumstances of the case. And certainly there's a lot of people that couldn't afford paying up to 2.5 million in penalties. But for companies, it goes a little bit higher. It can be the greater of 50 million, 3 times the value of the benefit obtained by the body corporate. And also when it comes to, their annual turnover. If there's an interference with privacy by a person, it could be $660,000 or 3.3 million for the larger entities. So I won't go through all of these any further because we'll need to move on, but I just want you to be aware there are these civil penalties and they can be quite expensive. So this is approaching the end of my presentation. I'll just have a few more slides after this. But what are the implications for health service providers? Well, let's look at it about this way. You've got data that you collect and records. You got patient records, staff records, and you got your operational data. For medical practice owners, you've got your director's duties and your data governance, which I discussed earlier. You've got to take those organizational and technical measures for data security. There's the civil penalties. Obviously, there's the court claims for serious invasions of privacy, if that can happen, and indeed the impact on your business reputation. So when it comes to medical practices, really, these are the issues you got to be mindful of. It's the engagement with your board if you're an owner of a medical practice and a company structure. It's the governance that you have in there, the measures you take for cybersecurity, for managing your relationships and your contracts with third parties, for your staff training, and all of these kinds of issues. And so I want to focus on this slide on the importance of cybersecurity because Chris is going to talk about it, but it's become to the point where the Australian Securities and Information Commissioner, which is basically the regulator for the Corporations Act and the duties of directors, in a recent case basically said that this company, the directors didn't take appropriate measures to address cybersecurity risk. That was a breach of their director's duties and they got a fine for it. So this company wasn't a health service provider. It had to do with Australian Financial Services license. But the point is, it's a company and its directors, and it can apply to you as well. So in this case, risk management is essential. What I'm going to do is just quickly read out what the ASIC chair had said in this respect, because it's really important for you to be mindful of how far they're going to go in investigating and enforcing the duties of directors. For all boards, cybersecurity and cyber resilience has to be a top priority. That's a direct quote from the ASIC chair. So just be mindful of that. Okay, so this is the final slide for me. When it comes to commercial legal considerations, these are the key takeaways. You've heard me mention a number of times, and it's so important, have a compliant privacy policy. Speak to your professional advisors in this respect. If you have any concerns, at least get it reviewed and make sure that from your staff and your doctors, there's an adherence to the privacy policy. If you're dealing with third parties and you contract with them, make sure you consider their privacy policies as well, because you want to know where the liability lies. If there's a data breach, what are your responsibilities? What are their responsibilities? Make sure you do the appropriate training for your employees and contractors. You familiarize yourself with key personnel and privacy obligations. And very importantly, get professional advice as needed. You really don't want to be caught in a situation where you might have something like a non-compliant privacy policy that gets the attention of the OAIC, and then you end up having to deal with a fine that could have been completely avoided. So thanks very much, everyone. I'm going to let Chris take over now, and we'll finish off with the Q&A at the end. Thanks, Chris.
Thanks, Marco. There's a lot there, but a lot of great stuff, and so much of what I'm going to say, is really important with regards to, excuse me, with regards to APP and the OAIC. But it's actually there's a much broader issue for organisations, regardless of the type of business that you are, where cybersecurity is absolutely at the, if you'll forgive me a medical pun, at the heart of it. Unintentional, that just came up, so I do apologise for anyone who's groaning. Look, I think Marco has mentioned, obviously, quite in depth about the OAIC, and sort of latterly there about ASIC. And I think the thing that I want to say is, and we recently had the introduction of the very first Australian standalone cybersecurity act. We have the Australian Signals Directorate, who are kind of, if you like, sort of, they're the cybersecurity eyes and ears for the country, and they have far-ranging investigation powers and far-ranging sort of authority for security within Australia. But there is a common theme with all of these regulatory bodies, government or specifically ASIC, etc., and that is the principle that directors, business owners, have a responsibility to their information security and their cybersecurity. You can, much like with your financial duties, where if you're on the board, ignorance is not a defence. You have to know about financial matters, and the same is true now for issues relating to cyber and cyber risk. So that's an extra element for you to consider at the board level, and this fits into really understanding the cyber risks that are posed to your organisation, the ones that are external, and what do you need to know? What are the questions you need to ask? What are the things you need to put in place? And if you think about all of this with one principle that comes through, there was a recent conference where all the regulators and the Signals Directorate and the Cyber Minister were all present, and a consistent theme, a consistent message was organisations need to understand what data they have, where is it, why have you got it, do you need it, and how secure is it? And if you think about all of these things through that lens, then you will cover off on the privacy issues, or some of the other requirements from ASIC, etc. So what have you got? Where is it? Why have you got it? Do you need it? And that's sort of important when you come to talk about when you need to dispose of data or de-identify data, and understanding how secure it is. So all of these things are really connected. And another key word that is throughout the legislation, and Marco has used it a number of times, is reasonable steps, and the sort of again that the OIC commissioner was at pains to sort of stress that organisations need to demonstrate that they've taken reasonable steps to have understood what data they've got, where is it, why do they need it, how secure it is. So let's talk about some of that. What are some of the things that you can do to be a cyber healthy practice? And sort of broken this down into four areas. I think the key message that I'd like everyone to take away is, if you haven't heard of or looked at the Australian Signals Director Essential 8, and we can perhaps provide a link or provide information to those who are going to watch this now or later, Marco, is the Essential 8, which is an Australian-based framework for organizations to understand and to mitigate and to secure their organizations. And as it says, it's 8 things. It's really simple, really easy to follow. And I hardly recommend looking at that because they are straightforward, they are practical. But what you want to be doing is you need to embed that culture of cyber compliance. And it starts at the board. It's understanding what are the questions you need to ask of yourselves. What do you know? What you don't know? How do you go about informing yourselves of those things? Making sure that you have the right frameworks and policies and procedures in place. As I say, the Essential 8 is a really good place to start. Key elements for the culture of compliance is making sure that you have a robust and regular training. Don't see it as just another governance thing that you've got to put people through just to tick a box. It needs to be regular, it needs to be engaging, and it needs to be something which keeps in the front of people's minds. Yes, cyber is a risk. I need to consider this in my day-to-day. And also, not only, and another message that is being forcefully put out there by the regulators is you must have plans in place. You must have a plan in place, and you must test those plans. And we'll come on to a little bit of that in a moment. But making sure you've got the right policies, procedures, making sure that you have the board well educated, making sure that people within the practice receive the right training and relevant training, and also making sure that you test the systems. Some of the things, as I say, I've been involved in cybersecurity for well over 30 years now, and we're still talking about in 2025 passwords and password strength. So, a very simple remediation is to ensure that robust passwords are used, as opposed to the most common password in use at the moment, which is password, or second most common, password 1, 2, 3, 4. Make sure that multi-factor authentication, and when we talk about that, quite a lot of organizations talk about it being not convenient for certain people within the practice or certain people within the organization, but it's absolutely essential. And again, something that the Essential 8 dictates is to have multi-factor authentication. And again, we talk about phishing a bit later, but making sure that you're keeping up to date with the latest trends in multi-factor authentication, whereby you're using phishing resilient means as opposed to just using an SMS text. Make sure that you are having the right conversations with your service provider, or if you have an internal team, make sure that you're having the right conversations with them. Now, a quick analogy, and this is an analogy, which is quite hard to say in quick succession, that I use with all my clients, but it's particularly relevant here, I think, is that if you think of your service provider or your MSP, or even your internal IT team, it is like going to your GP. It is like going to your regular doctor to say, hey, I feel a bit under the weather, or I've got these symptoms. The doctor will go through a series of questions and they will diagnose, and they will say, well, it sounds to me like you've got X, you need to see a specialist about that. Your MSP, your service provider, and your IT team generally, their role is to make sure that you have access to your services, to make sure that you get access to, most commonly, Office 365 or your internet, your email, to make sure that you can communicate with each other. Security isn't their prime function. There may be a consideration for it, but it is a specialism that is not necessarily within their remit. So make sure that you as an organization understand your security, your threats, and that you can define your processes and policies and impose those on your MSP, as opposed to being reactive to that. I've mentioned about incident response plans. Must have an incident response plan and test that, much like you would a fire drill. You need to make sure you test that. Again, it is a requirement. It is something that is expected. It's one of those reasonable steps within the Cybersecurity Act, but also from all the regulatory bodies. So again, Marco referred to this a couple of times. I think, why is this important? Why is this important? Why is this relevant to health service providers? Well, so this information comes from the OAIC, and it's around the notifiable data breaches report. Again, the links there. I encourage everyone to go and look at that, because there's some really interesting stats in there. But the most obvious ones, the most important ones for everyone here today, is you can see from that graph that this is all this, albeit this is from 2023. Don't get too comfortable, because 2024 wasn't much better. But you can see that the health service is specifically targeted and is double financial services. When you think, quite often when we talk to clients, they think about it in terms of pure monetary. Well, I don't have any. I don't deal with money. What information would I possibly have? Well, as Marco has so wonderfully outlined, the value in your organization is that personal data. That is what the cyber criminals are after. There is a whole economy that is geared up towards this. It's considered to be, last year globally, the cybersecurity, the dark web, the ransomware gangs, that whole dark economy is thought to be somewhere around $10 trillion globally. In Australia, it's thought to be something around $30 billion. It is a huge industry, and it is argued that if those numbers are correct, and it's quite hard to sort of necessarily verify all of those numbers, but that makes cybercrime the third largest economy in the world after the US and China. It is a massive problem. Health providers contain the information that these gangs are after, and it is borne out by the statistics that are shown there. As I mentioned, in 2024, look, ever so slightly better, but the healthcare providers still top the charts in terms of breaches reported. And I think, if I remember right, the stat is that of those notifiable breaches, 97% were as a result of some kind of criminal activity, as opposed to by accident. Now, so what does this mean? I've mentioned about the cost of the economy, but again, these come from the government. These numbers, they come out sort of every year or 2 years. These are the costs to the cost of cybercrime to the organization at an organizational level. Now, consider this in the context of the potential penalties that Marco has already mentioned. I can't remember the exact sort of numbers, but the penalties are quite significant. If you're then looking at this costing you as a, depending on the size of practice that you are, you fall into any one of those categories. It's a significant sum of money, notwithstanding any of the other reputational issues. Also, there has been the formation of the Cyber Incident Review Board, whose primary task is to actually investigate issues of compromise where they're considered to be nationally significant. Again, you might automatically think of something like Telstra or something like something in defence, but it's not hard to sort of suggest that, well, actually, if you're a large-scale service provider, or you're a hospital or something like that, you could fall into that. And now the Incident Review Board have very wide-ranging investigatory powers, and it's just another area of oversight or potential sort of penalties that you really want to be avoiding. I would suggest that the numbers there don't really indicate that the size of the business is necessarily the primary motivator, or it is what data do you hold, and arguably we find that the smaller businesses, or those sort of medium-sized businesses, the security is such that actually they provide a far more attractive target. I'll quickly go through this, and I won't. Perhaps, Marco, if it's okay, given time, I won't talk too much about the insurance side of things, but it's important to know the types of attack that go on. As I've mentioned, the economy there, trillions of dollars. The most common methods of attack are the phishing. So that is where an email is received. It sort of has some kind of call to action, some urgency about it, and says, click this link and do it within, or else. Or maybe there's some kind of, we've seen where what could be spreadsheets for finances. I'll click on this and you get taken to a website, and all of a sudden your machine is compromised, your credentials are stolen, and people are then on the inside of your system. Ransomware. I just wanted to quickly highlight this. So ransomware is obviously where these gangs, they will get into your system primarily through phishing. They'll get into your system, and then they will send you lock down your encryption system and say, unless you pay us X, we will release this data out to the dark web, or we will sell it to someone else, or we will, as is often the case, we will expose your patient's data, etc. So a really, really big issue, particularly as I mentioned within the healthcare sector. Just looking at the statistics for the last 6 weeks, there are at least 6. I won't name them. It's publicly available information out there, but I won't name them. But at least 6 healthcare providers of various sizes or various sort of forms have been ransomed within the last 6 weeks. So it is a very real issue for the industry because of the type of data that you hold. So not only is it really important to focus on all the stuff that Marco's spoken about, but keep thinking about what have you got, where is it, why have you got it, do you need it, how secure is it, and think about how you go about securing that data. I'll leave that there. We'll get on to questions now, and hopefully that sort of prompted a few thoughts. So please feel free to fire away with any questions.
Thanks very much, Chris. And yes, everyone, we've already received some questions in the Q&A. You have some of my colleagues helping to answer them, but please send them through. We've still got a few more minutes for this webinar, so if you do have questions, great time to put them through now. Otherwise, you can always watch this recording later. If you want to get in touch with Chris or myself, we do have our details here. And just feel free to email or to call us. But yes, we'll sit by and wait to see if we get any more questions come through. But otherwise, thanks again, everyone, for joining us. We really appreciate your time, especially if this is a lunch break for you and you've taken time away from perhaps going out somewhere to eat and you're sitting in front of a computer and listening to us.
So just on the Datto backup online data storage, again, go have a look at the Essential 8. The backups are absolutely essential. I won't make comment on a specific product, but if you have a backup, make sure you understand exactly what is being backed up, how it's being backed up, the security around where it's being stored, and again, please look into where it's actually being stored, because again, this is notwithstanding the whitelisting and the APP provisions, but it's important to know where some of this stuff is actually being stored in the cloud. But backups are great. Make sure they're encrypted. Make sure they're regular, and that's a really good key thing to make sure you get back up and running as quickly as possible.
Mm-hmm. I see there's been a question also about whether the whitelist has been currently published. No, and that's just because I think that's something that will eventually come, but the government has to consider which are the appropriate countries that will fall under. But if you are at this time using any third-party providers that are overseas and there's a flow of data overseas, it's really important that you have a get professional advice where possible to know what are the obligations under the terms and conditions for the arrangement that you have with them, just so you're aware of your own potential liability in that respect.
And again, not legal advice. I'm not a lawyer, and I certainly don't want to make Marco go prematurely bald with saying something like this. But I think there's some common sense to this. And I think it's probably fairly safe to say the countries that you can think of that are not going to be on the whitelist will probably not be on the whitelist, and sort of the regions that probably, or the countries that probably will probably be so. So I think it's worth thinking about that as to where that you currently send or store data, if you're doing that, just to get that in your mind and start thinking about it.
Chris, this might be another question that's come up from Ken that you might be able to advise on.
So the question, I have a registry which records de-identified outcomes. There is no contact with the prior stage of identifiable data. How should I protect this data on an Australian cloud server? Well, look, so as a broad answer to that around any data that's on the cloud, again, the first thing to really sort of do is that the most appropriate place for it to be? Should it be there? Is that is that really where it needs to be stored? And if it is, and you can't, there's no such thing as zero risk, right? But make sure that it is encrypted, make sure that it is backed up. But I think going back to it sounds like you've got a pretty sort of good a good idea about what you've got and where it is. But that whole exercise around understanding what data you got and where it is really, really important in terms of then again to your organizational risk register and really sort of assessing, well, okay, do we need to keep this stuff in the cloud? Is that an acceptable risk? What would happen if that becomes compromised? Should we store it somewhere else? Should it be actually sort of, it depends on how often you need to access that and use it. Is it kind of like live data as such? Could it be something that's in like a cold storage backup? So these are all sort of questions in thinking about the threat profile. But I would suggest the main thing would be make sure it's encrypted at rest and in transit, and making sure that it is indeed itself backed up.
Chris, I might use this opportunity off the back of that question to ask you something that a colleague alerted me to yesterday, whether or not that is something that you're aware of in terms of the nefarious people we have out there, the cyber criminals.
Yeah.
Where there is data that is de-identified, are you aware of any technology, including AI, that can take de-identified data from multiple sources, try to piece it all together into a puzzle to reasonably identify a person based on the collection of that unidentified data?
Great question. I think, what you're describing is effectively social engineering, which is what cyber criminals do now. Is they'll get a piece of information from somewhere, and they'll go elsewhere and they'll try and scrape data from that, and then try and piece all that together. I think the possibility of re-identifying de-identified data becomes, it would be quite an intensive exercise. And I think with AI, that kind of thing becomes less intensive because that can do a lot of the groundwork. I would say I don't know if anything specifically. I haven't heard of any gang or group doing that specifically. And I think for one really good reason, they don't need to. There's enough identifiable data that is insecure out there that they don't actually need to go down that road. But it would not surprise me if people are doing that, and I don't think it would necessarily be that hard to do, which is why it's so important that if you're holding whatever data, but certainly that PII, that identifiable, personal identifiable data, make sure it's encrypted.
Yeah. And another key thing to keep in mind that you mentioned earlier is how long do you really need to hold on to that for? There's statutory guidelines. Yep. But if that data is no longer useful, please, you should be removing it because it creates an obvious risk.
Well, and can I just give one example of that outside of the health? But it was in the legal forum where there was a law firm that had gone out of business, it closed its doors, I think something like 18 months ago. But they were recently subject of a data breach because they hadn't actually cleared all the data out of the cloud. It was still there. It was still accessible. So it's really, really important to map that data, understand where it is, do you need it, how long have I got to keep it, get rid of it when you don't need it. So it's all back to those policies and procedures, having a really good risk and governance framework around the data you hold and why you've got it.
Excellent. Well, everyone, I think that's it. We've answered